Case 1. Laurencia Bambi. In May 1981, Christine Schultz, the former wife of Milwaukee police detective Alfred Fred Schultz, was found dead in her home, her hands bound, gagged, shot in the back. Her 2 young sons asleep down the hall heard an intruder. Laurencia Bembenek, nicknamed Bambi by press, a name she despised, was no ordinary suspect. A former Milwaukee police trainee, she had been fired shortly before the murder. She had married Fred Schultz in early 1981, though the marriage was later declared invalid because Wisconsin law still mandated a waiting period after a divorce. After Christine was killed, she legally remarried Schultz. From the start, the case bristled with tension. Investigators found that Schultz's off-duty revolver, in his name, matched the fatal bullet in ballistics tests. Bembenek also had access to a key for Christine's house, one Schultz allegedly copied. No signs of forced entry implied inside access, and fibers, hairs, and even a wig discovered in a plumbing drain were matched to items associated with Bembenek. The prosecution painted a narrative: a woman unwilling to live in Fred's financial shadow, seeking freedom from alimony claims, and willing to kill to sever ties. Yet the defense saw a very different picture: a system bent on fitting a case to a suspect. They argued that several key investigative decisions were flawed. The ballistics tests might have been mishandled, evidence may have been contaminated or coerced, and there was potential manipulation by individuals close to the case. The eyewitness testimony was shaky. The older son saw an intruder described as a masked male figure in a green jacket with a ponytail, but could not later identify Bembenek in court. Prosecutors also offered testimony from witnesses who claimed Bembenek had offered money to have Christine killed. That narrative resonated in the jury room. In March 1982, a jury found Bembenek guilty of first-degree murder. She was immediately sentenced to life in prison. The press built her image as a femme fatale, a scandalous figure defined as much by beauty and controversy as by alleged guilt. But even as she began serving time, doubts grew. Over years, Bembenek and her legal team pursued appeals. New examinations introduced the idea that male DNA was present at the crime scene. New ballistics tests challenged the theory that Schultz's gun was the murder weapon. Investigators and judges later acknowledged that procedural errors, inadequate procedures, and bad judgment had occurred, though no deliberate misconduct was officially confirmed. The case was so entangled that in 1990, Bembenek escaped from a women's prison, traversed to Canada under an alias, was recaptured after 3 months, and in the process reignited public fascination and skepticism. That escape triggered a judicial review, resulting in the recognition of at least 7 major blunders in the original investigation. In 1991, Bembenek voluntarily returned to U.S. custody for a new trial. But instead of risking another jury verdict, she accepted a plea of nolo contendere to second-degree murder in December 1992. Under that deal, her life sentence was reduced. She was released after serving roughly 10 years and placed on probation. Bembenek died in 2010 of liver and kidney failure. She never achieved a full legal exoneration. To this day, her case remains contentious. Some still believe she was framed, others remain convinced she was guilty. Her legacy lives in books, documentaries, podcasts, and public fascination. Case 2. Amber Geiger. Amber Renee Geiger was a Dallas police officer approaching the end of a long night shift. Her apartment was on the 3rd floor, Unit 1378, of a 4-story complex. Unbeknownst to her, the unit directly above, 1478, was occupied by 26-year-old accountant Botham Jean. She parked her car on the 4th floor, mistakenly. In the moments that followed, she claimed she believed she was walking toward her own door. And when she inserted her fob into Jean's unlocked door, which responded differently based on whose fob was used, she pushed it open and confronted a silhouette in the dark. In that instant, she pulled her service weapon, yelling at the figure to show his hands, and fired 2 shots, striking Jean fatally. What was going on in her mind? Geiger asserted she thought an intruder was in her apartment and that she was defending herself. That claim, fear, confusion, a mistaken belief, is central to both the prosecution and defense. A psychological portrait emerges: an officer under exhaustion, possibly on autopilot, stepping into a situation she misread. The defense emphasized heavy fatigue, a confusing layout, and common errors among residents. But the prosecution countered that as a trained officer, she should have exercised caution, called for backup, or stayed behind cover instead of charging inside. The moment law enforcement arrived, investigators had a complex scene to unravel. Geiger, meanwhile, called 911, identifying herself as an off-duty officer and requesting EMS. Dallas police wrapped the crime scene evidence, and the Texas Rangers took over the investigation the very next day. They examined the door fob system. When Geiger's key fob was inserted into Unit 1478's door, a red blinking indicator showed it was the wrong fob. Jean's key fob generated a green light and unlocked the door. That contrast suggested she had entered the wrong unit. Forensic ballistics confirmed that shell casings came from her service weapon, and trajectory analysis from the medical examiner showed the shot path indicated Jean was bent over or rising, contradicting her testimony that he advanced at her standing upright. Investigators also found no drugs or alcohol in Geiger's blood, and no blood on her uniform. Detectives spoke with building residents. Many admitted to accidentally using the wrong hallway or inserting fobs in incorrect apartments, because the hallways had identical layouts and floor indicators were confusing. The Texas Rangers noted a surprising statistic. About 23% of residents between the 3rd and 4th floors had at some time used the wrong fob or visited the wrong unit. That testimony supported her defense of confusion, but the prosecution argued that an experienced officer should have noticed visual clues, e.g., red mats, different decorations, lighting differences, and responded more cautiously. Initially, Geiger was charged with manslaughter, a lesser charge, which triggered protests that the killing of an unarmed man in his own apartment deserved more. A Dallas County grand jury upgraded the charge to murder, citing evidence of intentional or knowingly causing death. The trial began in September 2019, after sequestering the jury due to intense media interest. The defense rested on claims. She had worked a long shift, was fatigued, the layout was confusing, and she genuinely believed she was in her own home defending herself. They emphasized that residents had often made the same mistake, and she acted impulsively under fear. The prosecution challenged that narrative. They argued her entry was commando style, that she ignored safety protocols, didn't retreat to cover, and failed to de-escalate. They highlighted text messages showing bias or insensitivity. They also pointed to differences in decoration, red mat outside Jean's door, her partner's texts noting different ways of working among black officers, and other evidence to challenge her mistaken entry defense. During sentencing, the jury heard private texts in which she mocked black colleagues and made offensive remarks. On October 1, 2019, the jury found her guilty of murder after about 6 hours of deliberation. The next day, they sentenced her to 10 years in prison. During the hearing, Jean's family made emotional statements. Jean's younger brother, Brant Jean, stunned the courtroom when he hugged Geiger, saying, "I forgive you." Geiger also testified, and her defense team asked for leniency referencing her personal history and remorse. Geiger's defense filed appeals, arguing insufficient evidence and errors in jury instructions, particularly around mistake of fact versus self-defense. Texas appellate courts rejected her appeals, affirming her conviction in 2021. In November 2024, a civil jury found her liable for wrongful death, ordering her to pay $98.65 million to Jean's family. In October 2024, she was denied parole, though she remains eligible for future review. Case 3. Stephanie Lazarus. In February 1986, 29-year-old Sherry Rasmussen, recently married to John Ruetten, was discovered in her Van Nuys condominium, beaten and shot. Investigators initially believed the crime was a home invasion gone wrong. The house showed signs of forced entry, stereo equipment was stacked near the door, and the narrative of a burglary seemed plausible. But others suspected deeper undercurrents. Sherry's father pressed detectives early to examine a troubled nurse she worked with, Stephanie Lazarus, Ruetten's former romantic acquaintance. But those early leads were ignored, sidelined by bias or assumptions that a police officer would not be a suspect. Psychologically, Lazarus presents a study in dual identities. She was, publicly, a committed officer who built a long LAPD career, eventually joining the art theft unit. Privately, according to letters and testimonies, she remained emotionally entangled in her past with Ruetten. Prosecutors later argued that jealousy and obsession fueled lethal intent. For years, the robbery theory held sway. The case went cold. Key evidence, including a bite mark on Rasmussen's arm, sat in storage. In 2001, cold case detectives reopened the file, and tracked the swab containing saliva to a medical examiner's freezer. In 2009, investigators quietly tracked Lazarus. They followed her, seized a discarded soda cup, and ran a DNA match. The bite mark evidence matched Lazarus's profile. Evidence frozen in time for over 2 decades now aligned with her own DNA. Her arrest in 2009 stunned the public, but psychologically, the trajectory makes grim sense. A pattern of denial, control, and secrecy. At first, Lazarus denied knowing Rasmussen, then claimed her memories were fuzzy, eventually stating she might have talked to her once or twice. At trial in early 2012, prosecution and defense clashed over motive, evidence, and procedure. Defense motions sought to suppress the DNA and challenge the search warrants. The defense argued the passage of time hindered her ability to prepare. Prosecutors painted Lazarus's actions as deliberate, methodical, and practiced. She used her police training to avoid leaving fingerprints, to mask her presence, to mislead early investigators. Jurors heard testimony from Ruetten about his interactions with both women, including claims Lazarus had once told him, "If I can't have John, nobody can." After several days of deliberation, the jury convicted her of first-degree murder. In March 2012, she was sentenced to 27 years to life in prison. She appealed, but her conviction stood. At sentencing, the emotional weight fell heavily on Rasmussen's family and on Ruetten. Their statements underscored how the betrayal cut deeper because the killer had sworn to serve. Observers noted how Lazarus's years in law enforcement gave her insight into how to evade detection. Since incarceration, Lazarus has repeatedly sought parole. In 2023, under California's reform laws for youthful offenders, a board recommended her suitability. But after pushback from the family, the full board rescinded that grant in 2024, citing inconsistencies between her account and the evidence, and a perceived lack of genuine remorse. Her parole hearings are ongoing, and the resolution remains unsettled. Case 4. Antoinette Frank. Antoinette Renee Frank joined the New Orleans Police Department in 1993. Her record was already troubled. During her application process, she reportedly flunked psychological evaluations, lied about work history, and drew scrutiny from internal hiring units. She was ambitious, determined, and perhaps desperate to prove she belonged, while hiding the scars she carried. Her early life, as later defense appeals would argue, was marked by repeated abuse at the hands of her father. Physical violence, emotional terror, perhaps sexual trauma beginning in her childhood. These folding pressures, her past on one side, the demands of a hypermasculine police culture on the other, formed a psychological crucible. Defense work later contended that she became vulnerable to coercive control, especially by a partner introduced in her life, Rogers Lacaze. On the night of March 4, 1995, Frank and Lacaze entered the Kim On restaurant twice under benign pretexts, picking up leftover food. But the third time, things turned dark. Frank, working off duty at the restaurant's security detail, entered again, then later borrowed a police cruiser to return to the scene. Meanwhile, inside, 2 family members, Ha and Quang Vu, were shot and killed, along with Officer Ronald Williams, who had been performing security. When police units first arrived, they didn't suspect her, but survivors had hidden themselves, heard Frank's name uttered, and later, when she returned posing as a responder, one survivor cried out that Frank had done it. Detectives pressed Frank and Lacaze separately. Within a relatively short time frame, both confessed. Detective Eddie Rance later said that in his 3 decades of homicide work, he had never encountered someone so cold and calculating. Investigators worked methodically, collecting witness testimony from those hiding in the cooler, from employees, from officers, tracing Frank's movements, examining her financial motives, and establishing her access to keys and police resources. An intriguing twist. A month after her conviction, police found a human skull with a bullet hole buried beneath her home, linked to her father's disappearance. Frank's trial kicked off in September 1995. The prosecution offered a narrative of betrayal. A police officer turned robber, murdering colleagues and civilians alike. Her defense, tragically, offered almost no mitigation. Despite prior motions to be declared indigent and receive state-funded psychiatric or social worker experts, those requests were rejected, limiting her ability to present her trauma or psychological profile. The jury deliberated for only 79 minutes before returning a guilty verdict on 3 counts of first-degree murder. In October, she was formally sentenced to death. Her co-defendant, Lacaze, also convicted, initially received death but years later had his sentence reversed and was resentenced to life without parole. On appeal, the Louisiana Supreme Court affirmed her conviction. The justices debated whether the court's denial of expert mitigation assistance prejudiced her outcome. While one dissent argued for a new sentencing hearing, the majority held that she wasn't significantly impaired in presenting her case. Over time, new evidence of her abuse history emerged in post-conviction filings, and several jurors later declared they would not have voted for death had they known that history. Decades into her sentence, Frank continues to fight. In April 2025, she filed a post-conviction appeal to overturn her death sentence, and a judge accepted it, ordering a new hearing slated for December 2025. Meanwhile, in May 2025, another judge blocked the state attorney general from stepping into the case, further complicating the legal path. As of now, no execution date has been set. Her clemency petition was denied in 2023, after a split vote by Louisiana's Pardon Board. Antoinette Frank's case remains a stark lesson. Even those sworn to protect are not immune to the corrosive pressures of trauma, manipulation, and institutional disregard. Her path from abused child to police officer to convicted murderer forces us to ask, how often do trauma and mental health go unseen behind places of authority? How many internal red flags go ignored until tragedy strikes? Case 5. Ingrid Olderock. She was born in Santiago, Chile, in 1943 to German immigrant parents. Her upbringing, according to researchers, was strict, authoritarian, and steeped in German discipline. Her father had arrived from Hamburg in 1925, her mother from Munich. In that home, speaking German was enforced. As a child, she internalized a worldview that prized order, hierarchy, conformity, and control. Some accounts and later interviews suggest she embraced Nazi ideology early. She allegedly said, "I have been a Nazi since I was a child." When women were first admitted to the Carabineros officer corps, Olderock entered their ranks. She went on to become the first female paratrooper in Chile, and claimed expertise in horse riding, dog training, martial arts, and shooting. Her credentials, real or exaggerated, allowed her to rise into the security apparatus. In 1973, after the coup, she joined the Dirección de Inteligencia Nacional, or DINA, the secret police of Pinochet's regime, where she was assigned to lead and train a women's detachment allegedly specialized in repression tactics. Olderock exemplifies a fusion of ideological fanaticism and authoritarian personality traits. Her early life reinforced rigid hierarchies. Once inside the regime's apparatus, she had both authority and a moral framework that justified absolute violence against designated enemies. She reportedly claimed to carry multiple weapons at all times, displayed open hostility toward pacifists, and manifestly disliked people she deemed weak. The combination of absolutist ideology, militarism, and the moral shielding of national security gave her a space in which cruelty became not a deviation, but a tool. One of the most infamous sites tied to her name is the clandestine detention center called Venda Sexy, Sexy Blindfold, a 2-story house in Santiago's Macul district. In survivors' testimonies collected in the Valech report and other investigations, Venda Sexy was known for sexualized forms of torture and humiliation. Among the most disturbing allegations, detainees claimed a German shepherd named Velodia was directed inside to assault prisoners, with Olderock allegedly supervising or encouraging that abuse, while other guards forced detainees into positions to facilitate it. One survivor, Alejandra Holzapfel, who was detained at 19, recounted that the dog was used to assault her while Olderock directed its behavior. Olderock always denied the charges, and she was never tried for them in her lifetime. Survivor accounts, careful documentation by Chilean human rights commissions, and investigative journalists mapped some of the patterns: abductions, forced confessions, disappearances, torture, sexual violence, and deliberate psychological terror. But for decades, the state's secrecy and political complicity blocked legal resolution. Unlike many high-ranking agents, Olderock lived free and largely unpunished, that is, until late in life. In 1981, she was attacked at her home by assailants who shot her in the head and abdomen. She survived with a bullet lodged in her brain. She claimed the attack was the work of leftist militants, the MIR. But in interviews and statements, she sometimes insisted it was orchestrated from within the security forces as retaliation for her alleged desertion. After the attack, she withdrew from active police duty and attempted to invoke amnesia when later summoned to testify about human rights cases. Her decline in health and possible cognitive deficits after trauma meant that even when formal legal processes ensued, she was never effectively held accountable before she died, in 2001, of a digestive hemorrhage, aged 57. Because of the Chilean truth and reconciliation mechanisms established after the dictatorship, many survivors' stories entered the public record through the Valek and Rettig commissions, giving basis for lawsuits and reparation claims. But despite persistent demands, there was never a successful criminal conviction of Olderuk. Her case remains an example of impunity in transitional justice. Her story has entered Chilean memory and cultural reflection. The animated short Bestia, inspired by her life, premiered in 2021 and won recognition internationally. Case 6. Adriana Rivas. In 1976, across the streets of Santiago, 7 political activists vanished, and with them, so did the promise of accountability. Decades later, a former nanny in Sydney was drawn into that same dark legacy. What follows is a story of power, denial, justice, and the hard questions that echo across borders. This is the case of Adriana Rivas. Adriana Rivas emigrated to Australia in the late 1970s, settled in Bondi, Sydney, and kept a low profile, working as a nanny and cleaner. In 2006, she was arrested in Chile when visiting family, accused of having participated in operations of DINA, the secret police under Pinochet. She was released on bail, fled to Australia, and from 2019 onward, has been held under extradition proceedings. In the documents from Chile, Rivas is named in connection with the Lautaro Brigade, an intelligence cell set against Communist Party members in the mid-1970s. Witness testimony claims she took part in forced entries, detention, interrogations, and by extension, at least oversight in torture operations. A former agent, Jorgelino Vergara, placed her in the same prison complex where brutal methods were deployed. Rivas has steadfastly denied active involvement in torture. She has claimed her roles were administrative, security, secretarial, translation. In public interviews, she expressed no regret for having worked for DINA, framing it simply as a job. Australia first acted on Chile's request in 2014, but delayed enforcement for years. In February 2019, New South Wales police arrested Rivas under an extradition order from Chile. What followed was a cascade of appeals. In 2020, a Sydney magistrate deemed her eligible for extradition over objections from her defense arguing political crime immunity. Her appeals failed. The federal court rejected review, and in 2021, the High Court declined to hear her final challenge. In 2024, she pressed a challenge in federal court to compel disclosure of complete legal advice behind the Australian government's surrender decision. That bid was dismissed. Justice Michael Lee held that even if her legal team did not see the full advice, it would not necessarily produce unfairness. This is a moment that underscores the tension between secrecy in national security decisions and the right to procedural fairness. The case remains unresolved, awaiting a final extradition determination by Australia's Attorney General. Because Rivas has not yet stood trial in Chile, there is no conviction, no sentencing. The story is one of legal limbo. Yet for victims' families, the absence of closure compounds their suffering. Adriana Rivas' story is not yet complete, but it forces us to consider how states hide behind normalcy, and how each individual, even in quiet roles, may carry weight in systems of injustice. This case will continue to unfold. I'll follow it with you, and together we'll watch whether justice finally arrives. Case 7. Nomia, Rosemary. Ndlovu. In her early years, Ndlovu presented as a committed police officer, rising through the ranks to become a sergeant stationed at Tembisa, Gauteng. Colleagues later recalled she had a compulsive gambling habit and sometimes fled work to avoid debts, a crack in her veneer that few noticed at the time. From 2012 onward, deaths began clustering unnaturally around her: a cousin, a sister, a niece, nephews, and her romantic partner. Each death, she claimed, was tragic but unsurprising, until pattern, timing, and money began to speak louder than grief. It was later suggested that her emotional detachment, capacity for manipulation, and lack of visible remorse, even in the face of horrific allegations, marked her as what one expert called a manipulative serial killer, someone able to disassociate her actions from the human cost. She treated her victims like financial assets, not people. The breakthrough came in 2018, when one of the hired killers she had approached to burn down a house, targeting her sister and her children, panicked and turned to the police. That tip triggered a sting. Undercover officers posed as hitmen collaborators, recording Ndlovu's instructions, her planning, and her mental coldness. Investigators tied her to policies and payout records. They used cell phone records to place her near victims before death, and insurance data showing she had taken out multiple policies, often without transparency, on relatives who died under suspicious circumstances. They also had co-witness testimony, including testimony from cooperating hitmen and state witnesses, over 50 in total, who described how Ndlovu had orchestrated or ordered hits. The investigative team watched a trusted officer become the prime suspect, overturning their own system's assumptions about loyalty and authority. When the case moved to the Johannesburg High Court, prosecutors charged Ndlovu with 6 counts of murder, multiple counts of attempted murder, fraud, and incitement to commit murder, and defeating the ends of justice. She pleaded not guilty, denying she ever orchestrated or benefited from the insurance policies on her relatives. In court, the state laid out methodical evidence, forensic linking, witness accounts, financial trails. The defense argued that she merely took out policies to avoid being financially burdened by funerals, but the weight of the coordinated evidence was overwhelming. Psychological assessments were introduced. The court considered whether Ndlovu could be rehabilitated, but the presiding judge found she showed minimal remorse. An apology she gave was described as tactical, not genuine. On 22 October 2021, Judge Ramarumo Monama convicted her on all 6 murder counts. The judge imposed life sentences for each murder count, together with additional decades for fraud, attempted murder, incitement, and defeating justice, a cumulative sentence of effectively life imprisonment. In his sentencing judgment, the judge explicitly balanced the triad of crime, the offender, and the interest of society. Given the gravity, the deterrent and retributive aims prevailed. Rehabilitation, where possible, would take a back seat. He found that no substantial and compelling circumstances existed to deviate from life imprisonment. Even after conviction, Ndlovu remained entangled in court. In 2024, she was brought back before the Kempton Park Regional Court on fresh conspiracy charges, alleged plots to kill her friend's ex-husband, and the detective who cracked her original case. Meanwhile, attempts to charge her with attempted murder of the detective investigating her original spree were postponed. Beyond her personal fate, the case sparked national discussion about the ease with which funeral or life insurance policies are taken on behalf of others, sometimes without their informed consent. It spotlighted gaps in oversight, fraud detection, and red flags in family policies. Experts and regulators urged reforms to tighten application vetting, consent verification, and cross-checking of beneficiary claims. The investigator who first cracked the case continued his work, uncovering further insurance fraud syndicates in subsequent years. In communities across South Africa, the horror of a killer cop forced families to re-examine trust with bonds and agencies. Case 8. Alfreda Fluker. Alfreda Janipril Fluker was a 15-year veteran detective with the Birmingham Police Department, assigned to the crime reduction team. She had been in a romantic relationship with a fellow detective, Mario Theodore White, with whom she also worked. In April 2020, tragedy struck. Kenesha Nicole Fuller, 43, was shot and killed while riding in an unmarked police vehicle alongside White. Fluker was later arrested and charged with capital murder, accused of opening fire into the vehicle in what authorities described as a domestic love triangle incident. Because the defendant was a fellow officer, oversight was critical. Local leadership requested the State Bureau of Investigation to take control of the probe to avoid conflicts of interest. A key piece: the trajectory of bullets into the vehicle, the location of casings, and whether Fluker's service weapon matched ballistic signatures. Though media coverage is less detailed on every forensics report, prosecutors argued that the evidence showed calculated targeting rather than a stray shot in a heated moment. Investigators also delved into relationship histories, prior complaints, Communications between Fluker, White, and Fuller. Emotional exchanges, jealousy, prior domestic incidents or warnings could help indicate whether this was impulsive reaction or long-brewing intent. The defense countered that the crime scene was chaotic, that Fluker acted in a moment of rage upon discovering an intimate betrayal. Early in the investigation, Fluker was arrested at her home hours later and held without bond. That decision itself reinforced prosecutors' framing, someone whose actions could not be trusted to pre-trial release. At trial, the prosecution painted Fluker as methodical, cold, and precise, a law enforcement professional weaponizing her training against a civilian. Witnesses were called to place Fuller and White in the vehicle, confirm the presence of Fluker nearby, and interpret timing. Prosecutors argued motive, perceived betrayal, jealousy, and desire to assert control. The defense countered with a different psychological narrative, that Fluker was overwhelmed by betrayal, that her emotional state spiked to a point where her judgment was compromised. They sought to humanize her impulse, framing it as in the heat of passion rather than a premeditated hit. Expert testimony may have debated her mental state, emotional stability, capacity for rational control under emotional duress. Public reporting suggests tension over whether this should be treated as cold murder or a crime of passion. A jury ultimately sided with the prosecution. On November 18, 2022, Fluker was convicted of capital murder. During trial, arguments focused heavily on whether evidence supported intent and deliberate action, or whether emotional breakdowns should mitigate culpability. On February 6, 2023, a judge sentenced Elfrida Fluker to life in prison without the possibility of parole. The decision reflected the gravity with which the court viewed an officer using lethal force outside any lawful justification. The sentence also included consecutive life terms for murder and attempted murder counts tied to the shooting of Fuller and attempted harm to White. During the hearing, statements emphasized that no title or badge shields a person from accountability. The victim's family expressed relief that the system upheld justice. No credible public record suggests that Fluker has undergone rehabilitation or appealed successfully to reverse the verdict as of now. Case 9. Kim Potter. Kimberly Ann Kim Potter was a 26-year veteran of the Brooklyn Center Police Department in Minnesota. On April 11, 2021, she was riding in a patrol car with a trainee officer. They pulled over a vehicle driven by 20-year-old Daunte Wright, citing an expired registration tag and a hanging air freshener violation. The trainee officer had requested backup, and Potter was ostensibly overseeing the situation. As officers attempted to detain Wright, he had a pending warrant. A struggle ensued next to his vehicle. Potter later said she intended to draw her taser, but accidentally drew her firearm instead and discharged one shot. Wright drove a short distance, crashed, and died at the scene. Potter was heard shouting, "Taser! Taser! Taser!" immediately before the shot. The aftermath triggered protests in Brooklyn Center, Minnesota, and a broader national debate over policing and accountability. Within days, both Potter and the police chief resigned from their positions. To understand how a seasoned officer might confuse a firearm for a taser, psychologists point to slip and capture errors. This phenomenon occurs when under stress, a deeply ingrained behavior overrides a less practiced one. In Potter's case, the argument was that pulling a taser in high-stress conditions was so routine it overshadowed consciousness of weapon type. The defense introduced expert testimony to this effect. But experts also questioned whether adequate training, muscle memory, perceptual cues, and grip design, a gun feels different than a taser, could realistically lead to that confusion. Moreover, stress narrows cognitive bandwidth. In that moment, split decisions about threat, controls, resistance, and weapon choice happen within fractions of a second. The prosecution argued that an officer must always maintain control. Even mistakes can be criminal when the stakes are life and death. Potter had no prior disciplinary record. That fact became central. Was she a well-intentioned officer making a tragic error, or someone whose split-second choice should bear criminal responsibility? That tension anchored much of the trial's psychological conflict. Immediately after the shooting, Potter was arrested and charged with second-degree manslaughter just days later, April 14th. She was released on bail later that same day. As investigations deepened, the state added a more serious charge: first-degree manslaughter predicated on reckless firearm use. The Minnesota Attorney General's office took the lead, with lead prosecutor Matthew Frank, who had also worked on the Chauvin case. Before trial, Potter's defense moved to admit evidence of human error theories, including slip errors. Judge Regina Chu granted that motion, allowing the jury to consider that framework. The trial began November 30, 2021, in Hennepin County District Court, with jury selection, rules of evidence battles, expert witness motions, and juror sequestration in place. As the trial unfolded, prosecutors emphasized recklessness and a duty to maintain control of a weapon. They argued that confusion should never justify discharging a firearm when non-lethal alternatives were intended. The defense countered with expert testimony about stress, perceptual lapses, and training limitations. They asked the jury to see Potter's experience, clean record, and lack of intent to kill. In her own testimony, Potter broke down emotionally. She insisted she yelled, "Taser, taser," and maintained she never intended to fire her gun. She said she never observed Wright holding a weapon or verbally threatening violence. She apologized to the Wright family, stating the event would haunt her. Several defense experts explained how misgripping a weapon, expectancies, situational cues, and design similarities in holsters can contribute to confusion. The prosecution's experts emphasized that training and weapon design should prevent such errors. After closing arguments on December 20th, the sequestered jury deliberated for about 27 hours across 4 days before returning a verdict on December 23rd. The jury found Potter guilty on both counts, first-degree manslaughter and second-degree manslaughter. Sentencing took place February 18, 2022. Wright's family delivered poignant impact statements. Potter addressed the court, apologized, and said she would live with regret. Judge Chu opted for a 2-year prison sentence, downward from the state request of 86 months. She reasoned that Potter made a tragic mistake and did not abuse her position of authority. The Wright family was deeply critical, calling the sentence insufficient and expressing heartbreak. Potter served 16 months before being released in April 2023, under supervised release for the remainder of her sentence. Her early release was timed carefully, pre-dawn, amid security concerns. Since release, Potter has participated in law enforcement conferences, speaking about her experience and warning others to avoid similar errors. She has collaborated with Imran Ali, a former prosecutor in her case. However, that work has been met with controversy. To some, it's a path toward redemption and prevention. To others, including the Wright family, it feels exploitative, reopening trauma with little real accountability.